Have you ever heard a joke so bad it, like, landed someone in court?
Oh, yeah.
Well, that's kind of what happened.
Yeah.
In this case, Wilkinson v. Downton, from 1897.
Wow.
Yeah, and it really set this huge precedent for how we think about emotional distress and the law.
Hmm.
So we're taking this deep dive into this fascinating case because, believe it or not,
Okay.
it's still shaping legal decisions,
Really?
even over a century later.
Wow, that's incredible.
Yeah.
I mean, what's truly remarkable is that, this case emerged long before emotional distress was even like a recognized legal concept.
Right.
Back then, the law was primarily focused on physical harm, and property damage.
Yeah.
This case really forced the courts to grapple with the idea that words alone could cause real actionable harm.
Okay, so let's paint the scene here.
Yeah.
It's 1897. Mrs. Wilkinson is going about her day, and she gets hit with some shocking news about her husband.
The news is that her husband has been severely injured in an accident.
Oh, no.
Broken legs, terrible injuries, the whole works.
Oh, wow.
Except it's all a lie.
A cruel joke.
Exactly. Mr. Downton just concocted this elaborate story as a prank.
And Mrs. Wilkinson's reaction to this?
She was utterly devastated.
Yeah.
But her reaction went beyond just like feeling sad or upset.
Right.
The shock led to physical symptoms like vomiting, and she experienced severe nervous distress.
Oh, wow.
This wasn't just like a fleeting emotional response.
Right.
Her distress was prolonged and debilitating.
That's intense. I can see why she decided to, take legal action.
Yeah.
But what was her legal basis for suing?
Right.
There was no physical assault or property damage.
And that's where things get interesting. Wilkinson sued Downton,
Sure.
but at that time, there was no legal precedent for suing someone purely for causing emotional distress.
Wow.
This case really pushed the boundaries of tort law.
So the court had a huge dilemma on their hands.
Yeah.
Could the law actually provide a remedy for something as intangible as emotional distress?
Right.
This wasn't like a broken arm or a stolen car.
Yeah.
The harm was psychological.
Precisely.
Yeah.
And the court's decision was a game changer.
They sided with Mrs. Wilkinson.
Yes.
Okay.
The court found Downton liable for intentionally inflicting emotional harm through his deceitful words.
Wow.
It was a landmark moment because it established intentional infliction of emotional distress,
Okay.
or IIE, as like a valid legal claim.
Wow. So a case from 1897 actually created this whole new legal concept.
It did.
I can see why this case is still so relevant today.
Absolutely.
But how does this concept of IIE actually work in practice? What are the specific elements that need to be proven?
Yeah.
I mean, words can be hurtful,
Right.
but surely not every offensive statement is grounds for a lawsuit.
Oh, absolutely not. You're absolutely right. Not every insult or like offensive joke
Right.
is going to meet the legal threshold for IIE.
Okay, so let's break that down.
Okay.
What exactly has to happen for someone's actions to qualify as, intentional infliction of emotional distress?
So there are 4 key elements that need to be established for a successful IIED claim. First, the defendant's conduct has to be truly outrageous and extreme. We're not talking about just like everyday annoyances or, hurt feelings.
Right.
The conduct has to go beyond the bounds of what's considered acceptable in a civilized society.
Okay, so we're talking about behavior that would shock the conscience, right?
Exactly.
Like a reasonable person would see it and say, that's just messed up.
Yeah. The second element is intent. The plaintiff has to prove that the defendant intended to cause severe emotional distress
Right.
or acted recklessly with a disregard for the potential consequences.
So it's not just about the outcome. It's about the defendant's state of mind.
Yeah.
They had to be aware that their actions were likely to cause serious harm.
Right. The third element is causation.
Okay.
The plaintiff has to prove that the defendant's conduct was the direct cause of their emotional distress.
That makes sense. You need to show a clear link between the defendant's actions and the plaintiff's suffering.
Exactly. And finally, the fourth element is that the plaintiff's emotional distress must be severe. Again, we're not talking about just minor inconveniences or, passing sadness.
Right.
The distress has to be significant and debilitating.
Yeah.
Something that interferes with the plaintiff's ability to function in their daily life.
So it's not just a question of whether someone's feelings were hurt.
No.
It's about the intensity and the impact of the emotional distress.
Right.
It has to be severe enough to warrant legal intervention. This is all getting really interesting.
Yeah.
It sounds like proving IIED is actually quite complex.
It definitely can be.
Yeah.
There's a lot of nuance involved in applying these elements to real-world situations.
Okay.
And keep in mind, different jurisdictions might have slightly different interpretations of IED.
Okay, so let's talk about those real-world applications.
Yeah.
We've touched on bullying and harassment.
Right.
But are there other types of cases where Wilkinson v. Downton has come into play?
Oh, yeah.
I mean, this case is over a century old.
It is.
Is it really that influential?
It's been incredibly influential. Its principles have been applied in cases involving all sorts of harmful conduct.
Wow.
From like debt collection practices to employment disputes to even family law issues.
Wow, that's a pretty wide range.
Yeah.
Can you give us some specific examples?
Sure.
I think it would be really helpful for our listeners to see how this seemingly simple case from 1897 is still shaping legal decisions today.
Absolutely. Let's take debt collection practices, for instance.
Okay.
Imagine a debt collector who repeatedly calls a debtor in the middle of the night,
Oh, wow.
using threats and intimidation tactics.
Oh, jeez.
That kind of behavior could definitely meet the threshold for outrageous and extreme conduct,
Right.
especially if the debtor has a medical condition that's like aggravated by the stress.
Yeah, that goes way beyond just reminding someone to pay their bills.
Right.
It sounds like a deliberate attempt to inflict emotional distress.
Exactly. Another example could be in the realm of employment law.
Okay.
Let's say a supervisor creates a hostile work environment by constantly belittling and humiliating an employee. Right.
In front of their colleagues.
That sounds awful. I can only imagine the emotional toll that would take.
Right. If the employee can prove that the supervisor's conduct was intentional or reckless,
Okay.
and that it caused severe emotional distress, they might have a strong case for IID.
These examples are really bringing it home for me.
Right.
It's fascinating to see how a case from 1897 is still relevant to so many different contexts.
It really is.
But it also makes me wonder,
Yeah.
are there any potential downsides to this legal concept? Could it be misused or abused?
That's a great question, and it's one that legal scholars and courts have grappled with.
Okay.
One concern is that IIE claims could be used to stifle free speech
Right.
or punish people for simply expressing unpopular opinions.
That's a valid point. We don't want to create a situation where people are afraid to speak their minds for fear of being sued.
Right.
So how do we balance the need to protect people from emotional harm with the right to free speech?
That's where those specific elements we talked about earlier become really crucial.
Okay.
Remember, the conduct has to be outrageous and extreme.
Yeah.
Just expressing a controversial viewpoint or engaging in heated debate
Right.
isn't enough to qualify for IED. The courts are very careful to distinguish between protected speech and conduct that crosses the line into intentional infliction of emotional distress.
So there are safeguards in place to prevent frivolous lawsuits and protect legitimate free speech.
Exactly.
That makes me feel a bit better. But are there any other potential challenges or controversies surrounding IIED?
Well, another challenge is proving the severity of emotional distress.
Right.
Unlike physical injuries, which often have visible evidence,
Yeah.
emotional distress is subjective and internal.
That makes sense. It's not like you can take an X-ray of someone's emotional state.
Right.
So how do you prove that someone's distress is severe enough to warrant legal action?
It often comes down to a combination of factors.
Okay.
The plaintiff's own testimony about their experience is important, of course.
Right.
But courts will also look for corroborating evidence.
Like medical records, therapy notes, or
Yeah.
testimony from friends and family who can attest to the changes they've observed in the plaintiff's behavior and well-being.
So it's a bit like putting together a puzzle.
Yeah.
You need multiple pieces of evidence to create a clear picture of the severity of the distress. This is all so insightful.
Good.
It's like we've peeled back the layers of this legal concept
Yeah.
and really gotten to the heart of what it means and how it works.
I agree. It's been a fascinating exploration, hasn't it?
It has.
And we're not done yet. We still need to delve into some real-world examples of how Wilkinson v. Downton has been applied in modern legal settings.
Okay.
Those examples will really bring the impact of this case to life.
All right, so we've unpacked the elements of IIED, but I'm really curious to hear about some actual cases where Wilkinson v. Downton has made an impact.
Yeah,
Can you share some examples of how this legal concept plays out in today's world?
absolutely. There's a landmark case, Snyder v. Phelps. That provides a really fascinating illustration of the complexities of IIED and free speech.
Mm-hmm.
You might remember this case.
Yeah.
It involved the Westboro Baptist Church
Right.
picketing the funeral of a fallen soldier.
Oh, wow. Yeah, that one was all over the news. The things they were saying were truly horrific.
Yeah.
But wasn't their picketing protected by the First Amendment?
That was the central question of the case.
Okay.
The soldier's father, Albert Snyder, sued the church for IIED.
Right.
arguing that their hateful speech at his son's funeral had caused him severe emotional distress.
That makes sense. I can't even imagine the pain he must have been going through. And then to have these people show up with those signs and chants.
Yeah.
It's hard to believe they could get away with that.
The case went all the way to the Supreme Court.
Wow.
And it sparked a huge national debate about the boundaries of free speech
Right.
and the right to protect oneself from emotional harm.
So what did the Supreme Court decide? Did they side with the grieving father or with the church's right to free speech?
In a very close 8-1 decision, the Supreme Court actually ruled in favor of the Westboro Baptist Church,
Really?
finding that their speech, although deeply offensive, was protected by the First Amendment.
How could that be?
The court emphasized that the First Amendment provides broad protection for even hateful and unpopular speech, especially when it addresses matters of public concern.
Okay.
They found that the church's picketing, while undoubtedly hurtful to Mr. Snyder, was focused on broader societal issues rather than being directed specifically at him or his son.
So even though their words were clearly intended to provoke outrage and distress, the court felt that their right to express those views on a public sidewalk, even in this incredibly sensitive context, trumped Mr. Snyder's right to be protected from emotional harm.
Exactly. The Snyder v. Phelps case highlights the tension that can exist between free speech rights and the desire to protect individuals from emotional harm. It shows how courts have to carefully balance these competing interests, often in very difficult and emotionally charged situations.
That makes a lot of sense. It's definitely a case that makes you about where the line is drawn. Are there any other modern examples that illustrate how Wilkinson v. Downton is being applied today?
Absolutely. Another interesting area where we see IID claims arise is in the context of online harassment and cyberbullying.
That makes sense. The internet can be a breeding ground for all sorts of nasty behavior.
Yeah.
And I can see how online harassment, especially if it's relentless and targeted, could cause severe emotional distress.
You're right. With the rise of social media, we've seen a surge in cases involving online harassment and cyberbullying. And IID has become an important legal tool for victims seeking redress. Take, for example, the case of Herrick v. Grindr.
Okay, I've heard of Grindr. It's a dating app, right?
Right. It's a dating app geared towards LGBTQ+ individuals.
Okay.
In this case, Matthew Herrick sued Grindr after his ex-boyfriend impersonated him on the app.
What?
Creating fake profiles that sent hundreds of men to Herrick's home and workplace for sex.
Wait, what? That's insane. So this guy essentially weaponized the app to harass and humiliate his ex. I can see how that would cause serious emotional distress.
Exactly. Herrick argued that Grindr's failure to adequately respond to his complaints about the harassment constituted intentional infliction of emotional distress. And the court agreed.
Wow. So even though Grindr wasn't the one directly creating the fake profiles, they were still held liable for the harm caused to Herrick because they didn't take sufficient action to stop the harassment. That's a pretty big deal.
It sets a precedent for holding online platforms accountable for the harm that occurs on their platforms.
Right.
It underscores the responsibility these platforms have to protect their users from abuse and harassment.
This deep dive has been incredibly eye-opening. I feel like I have a much deeper understanding of how Wilkinson v. Downton, this seemingly simple case from over 100 years ago, continues to shape our legal landscape and influence how we think about emotional harm.
It's a testament to the enduring power of legal precedents. Wilkinson v. Downton helped us recognize that emotional distress is real, that it can have devastating consequences, and that the law can play a role in holding people accountable for intentionally inflicting that harm.
From cruel pranks to cyberbullying, this case has left an indelible mark on our understanding of how words, actions, and technology can be used to cause emotional harm. It's a reminder that our emotional well-being deserves protection, just like our physical safety.
And while there are certainly complexities and challenges in applying IAED, particularly in light of free speech considerations, this legal concept continues to be a valuable tool for seeking justice and holding people accountable for their harmful conduct.
So the next time you hear a joke that's a little too mean-spirited or encounter a situation where someone's words are intentionally causing distress, remember Mrs. Wilkinson and the legacy of her case. It might just make you think twice about the power of words and the importance of treating each other with respect and empathy.
And remember, the law is constantly evolving to keep pace with our changing understanding of human behavior and the ways in which harm can be inflicted. Who knows what new challenges and legal interpretations await us in the future?
That's a great point. We'll just have to wait and see what the next deep dive reveals. Thanks for joining us on this fascinating exploration of legal history and its modern-day relevance. Until next time, stay curious, stay informed, and remember, words can indeed have a powerful impact for better or for worse.